Just back from giving a Vistage talk in Louisiana, and a question came up which has been a recurring question and a theme, so I thought perhaps I would address the question in a video. And what it has to do with how do you make changes to an otherwise irrevocable trust. So most of us are familiar that there are two different types of trusts. You have what are called revocable trusts and you have irrevocable trusts. And they serve different purposes. Typically, a revocable trust is designed for primary or for basic estate planning, which allows for an orderly distribution of trust assets upon the passing or incapacity of the trust maker. And it's generally designed to allow flexibility for changes in family circumstances, economic circumstances, et cetera, et cetera. But another type of trust deals more with tax issues or long-term family planning, and those are mostly designed within what are called irrevocable trusts. And unlike revocable trusts, you cannot make changes to an irrevocable trust. So the concern comes up is, well, I'm afraid about making an irrevocable trust because if I make one, what if something changes? What if I get remarried? What if I don't like my in-laws? Or what if my economics change and I need to get access to those assets? We use a lot of irrevocable trusts in the asset protection arena. Because if the trust maker themselves is able to willy-nilly revoke the document, then it wouldn't provide much asset protection because they could be compelled under court order to revoke the document. And if you revoke the document, all the assets come back to the trust maker and therefore no asset protection. So in our practice, we incorporate another party. That party is called a protector. And the protector's primary role is to add a degree of flexibility into an otherwise irrevocable document and also to give some assurances that to this trust maker that the document can be modified to kind of reflect current circumstances, whether they be, again, economic circumstances, lawsuit-based circumstances, or, again, family-based circumstances. So the protector's main role is one, it's always to be kind of the protectors to protect the settler from the activities of the trustee themselves. So therefore kind of adds a degree of control and comfort to a trust maker by appointing a third-party trustee that they themselves may actually be reliant on. It also makes sure they are responsive. That is, the trustee is responsive to the beneficiaries because you have the power to remove and replace the trustee. That's one of the protector's powers. Change in laws, their change in circumstances, adding beneficiaries, removing beneficiaries, controlling distributions, either increasing distributions, limiting distributions, appointing advisors to watch over advisors, whether they be trustees, financial advisors, insurance agents, to make recommendations, to act kind of as a trust advisor, as a go-between, a primary point of contact or communication between the trust maker themselves and the trustee who's ultimately administering the trust for them. So there's a lot of benefits to including a trust protector within an otherwise irrevocable situation. A lot of times we wind up using those to make modifications to beneficiary lists or modifications to modes of distribution. Comes up quite often because it could be a divorce situation, a creditor situation, a drug and alcohol situation. Again, you want to be able to build those flexibilities into an otherwise irrevocable trust. So don't be afraid when someone says, I have a trust, but I'm afraid about making it irrevocable. I don't know what circumstances may bring. Instead, make sure you have protector services. So here at Barth Agency Services, BAS, one of the services that we provide is Trust Protector Services, and we'd be more than happy to fill that role for you. If you have any questions, please give me a call. My name is Brad Barth. I'm the partner here at Barth Calderon, where we plan for all of your tomorrows. Thank you. Bye-bye.